So welcome to another one of our webinars. Today we're talking about death and superannuation. Beautiful sunny day to talk about a gloomy and sad topic. No, it's going to be great, and thanks to Tim Baumann from MurphySchmidt for presenting today. My name's James Farrell. I'm from Community Legal Centres Queensland. And can I begin the session by acknowledging the traditional custodians of the lands from which we're meeting. There are people from across the country online, and we thank you all for joining us this afternoon. We all acknowledge that we live and work on Aboriginal land. I've emailed around to everybody a copy of Tim's PowerPoints, which he shared with us a little bit earlier. So you should be able to access those from our website, and hopefully we'll have a recording available on the website later this afternoon or tomorrow as well. There are a couple of ways that you can ask questions as we go. One is to type a question into the questions box on your GoToWebinar control panel. And the other way is to press that button that looks like a hand. We'll see something that looks like a hand going up at our end. You'll be able to unmute your microphone and you'll be able to ask a question that way. Webinars aren't great for conversational style teaching and too many questions through the webinar. So if you can, we'd encourage you to hold your questions over until the end of the session. Tim will make sure that we've got plenty of time to answer those queries. I think that's my introductory and administrative stuff ticked off. So again, welcome and thanks to Tim Baumann from MurphySchmidt, returning, running the gauntlet again to deliver another one of our webinars. Thanks very much, Tim, and over to you.
Thanks, James, and thank you everybody for making yourself available today. This webinar sort of came about following the last one James and I put together on family provision claims, and we discussed what other issues in an estate context bear some comment as it currently stands, and we discussed the important role in which superannuation plays in both estate planning matters and also particularly estate litigation matters. Just quickly about myself, I'm a senior associate at MurphySchmidt Solicitors in Brisbane. I act purely or practice purely in the estates sphere, all aspects of planning, administration, also litigation. As I mentioned last time, I'm also on the management committee of Lawright, formerly QPilch, and our firm and myself maintain an involvement in the Homeless Persons Legal Clinic and the self-representation services with the courts and also the QCAT jurisdiction. So that I think provides me, or at least some assistance in providing me with a bit of an insight into the day-to-day issues that sometimes crop up in advising people generally in this space. The scenario which we often see from clients coming to some of the community legal services are their queries following the death of a loved one or someone they've known. And sometimes it can simply be a matter of, you know, what is necessary, what is needed, but sometimes they say things like, well, you know, I've been left out of an estate, or they might talk about wanting to challenge a person's will or their estate, or they may be have enough insight in terms of the estate, what it comprises of, to know that there are some superannuation benefits there, and they would either like to apply for them or access them in some way. This is a particularly relevant discussion, I think, given the compulsory nature of superannuation contributions by employers and the ever-increasing superannuation disputes and their role in estate disputes generally. You know, we're seeing it more and more, and I think it's imperative that in advising some of our clients, we have an understanding broadly about the way in which some of this fits into the overall estate context. Like all webinars, we're only given a period of time to chat, so I'm not going to be canvassing all aspects of superannuation. This is just simply not enough time. I make the point there in the first dot point that it's not skewed towards an estate planning style webinar. It's not attempting to give everybody a a way in which to approach an estate plan. That's not the nature of this webinar. Similarly, we're going to be largely focused on retail and industry superannuation funds as opposed to self-managed superannuation funds. Now, those are broadly the two categories of superannuation funds which are out there. The majority of the population have a retail or industry superannuation fund. Self-managed superannuation funds are usually only when someone moves up into a particular level of assets that really justify having some sort of structure like that in place. Also will not be canvassing the taxation consequences of the payment of superannuation death benefits. Now, I should say that is still a very relevant part of any superannuation discussion, but I will touch on it broadly, but certainly this webinar is not an in-depth analysis of that. Superannuation, of course, broadly, the first compulsory retirement savings scheme was extended to all employees in 1992 by the federal government. There were certain schemes under some of the union bargaining agreements and these sorts of matters that did provide for a compulsory retirement savings scheme, but the first time which it was extended to all employees was in 1992. And if you just look at that second point there, superannuation assets currently total $2.2 trillion, which is an extraordinary amount of money, hence why this space is such a relevant one, and increasing your knowledge of it can only benefit yourselves and your clients. Over almost 15 million Australians having at least one superannuation account, and as we know, often having multiple superannuation accounts. It's obviously worthwhile to consolidate those accounts, but the nature of work and the transient nature of it sometimes means that we manage to accumulate many. The final point there is about group insurance cover, and this is probably the most significant aspect of superannuation and the effect of it to enrich somebody's estate or somebody's financial position. Most industry and retail funds have an automatic group insurance cover. When you sign up to the fund, you might notice it when you fill out the paperwork, but it talks about an insured benefit. Now, a lot of people, when you ask the question of them, how much do you have in superannuation, they respond purely along the lines of what they hold in accumulated benefits, what they have been able to effectively amass as a result of the compulsory contributions their employer makes. What they often overlook, though, is the effect of an insured benefit, which is often many hundreds of thousands of dollars sometimes, which can have on death the effect of converting a superannuation balance with $5,000 into it and replacing it with one with a couple $100,000. So it's highly relevant and highly significant from the point of view of our discussion today. This is probably the mantra that you need to recall in respect of superannuation, and that is the general rule that superannuation benefits do not automatically form part of the estate of a deceased person. Now, that can, of course, create difficulties for clients to understand the nature of that as an asset, is because when people often have their own wills created by post office wills or just at home or however they do it, they often overlook the fact that the ability of their testamentary instrument or even on intestacy, the rules of intestacy to apply to superannuation is limited. The only way in which a will or the intestacy provisions can have some relevance to superannuation is if the superannuation is paid into the estate. Otherwise, the fact that someone has written a will saying they want their assets to go in a particular way may have no impact at all upon the way in which superannuation is ultimately distributed. I've got the point there about superannuation is not yet your money, and that's in fact how it how the position of superannuation is administered. In order to obtain certain concessional taxation treatment under the Tax Act, superannuation funds need to opt in to a detailed regulatory scheme. The most common form of a super fund is an express trust arrangement, which is constituted by a trustee which complies with the Commonwealth legislation. And so, as you might be aware, any trust asset upon the death of a superannuation fund member does not automatically impact upon the ownership of that asset. It's not a personal asset, it's a trust asset, and so it will continue to be held on trust on the death of that member, which is why it's such an important concept in terms of superannuation. Super can be released either completely or partially, only in a certain number of ways. If you retire, reach the preservation age and retire, if there is some sort of permanent incapacity, severe financial hardship, terminal medical conditions, these are some of the terms of full or partial release, but relevantly for us today, when someone dies. Under the relevant superannuation legislation, which is the Superannuation Industry Supervision Act, and also the accompanying regulations, there is an obligation on super funds to cash superannuation benefits as soon as practical after the death of a member. Now, the term cash effectively means to remove it from the superannuation environment. What that effectively means is that a benefit must therefore be paid from the fund, usually by either a lump sum or one or more pension payments to a dependent. So it's an important concept. On the death of a member, it has to be paid out of the fund. The relevant question, of course, is then, well, who can receive it? Because it is not an open slather. You have to fall within the criteria and the definition under the legislation to, in fact, receive that benefit directly. The two criteria are set out on the slide. You must be a dependent of the deceased or their legal personal representative, that is, their estate, in effect. Now, the ability of a super fund to pay it to an estate brings into being or relevance what sort of will that they had. And so if it is paid to somebody's estate, then the will have an impact and has the ability to distribute proceeds in a particular way. There is, just for interest, a catch-all provision because as rare as it might be, there are some times when a dependent or an executor or administrator can't be found. There is an ability for the super fund to release funds, but it occurs very rarely, but just for your own interest. Who is a dependent is the next question that must be answered, and I've listed under the Superannuation Act there the relevant people that fall into that category being a spouse, a child, someone in a financially, or those who are financially dependent on the deceased, and those in an interdependency relationship with the deceased. Importantly, under the Act, spouse includes those who are legally married, of course, those whether of the same or different sex in a registered relationship under the various incarnations of the Registered Relationship Acts throughout the country. And in addition to that, anyone who is living with the deceased on a genuine domestic basis in a relationship as a couple. There are a number of factors for that last point about what is in fact a genuine domestic basis, factors which are looked at to determine this, the nature of the duration of the relationship, the extent of common residence, the existence of a sexual relationship, the degree of financial dependence or interdependence and what the arrangements are, the ownership and use of property, care and support of children, and the public face, if you like, of that relationship, all go to determining whether or not someone is to be considered as living in a genuine domestic basis as a relationship of a couple. Child is an interesting definition in that it is appropriately wide. It includes adopted children, stepchildren, ex-nuptial children, and interestingly, a child of the person's spouse. Now that's relevant, of course, if your de facto spouse brings with them to the relationship a child of a previous union. For the purposes of the superannuation legislation, they would be considered a dependent and could in fact apply for your superannuation benefits in particular circumstances. That relationship, though, ceases upon the death of their biological parent. So if the stepchild's mother or father dies prior to you being the relevant person for this discussion, the relationship of stepchild then ceases under that Act. Financially dependent is an interesting category because it's not strictly provided for under the Superannuation Act. It's actually, the incarnation of it comes through some of the case law that was considering superannuation trustees and terms prior to the inclusion of the interdependency definition. And what we have there is a number of ways in which people can satisfy a trustee that they are financially dependent on a deceased person. It's often claimed by those who are unable to satisfy one of the other categories of being able to access the superannuation. The trustee of the fund where the superannuation is held may specify the necessary degree of financial dependence. The claimant might need to be wholly dependent or partially dependent, depending upon the terms of the deed. Financial dependency cannot be established by the mere giving of money. There must be some reliance on the financial support provided. The level of reliance need not be total. There was a case where a mother succeeded in arguing that she was partially financially dependent on her teenage son, who paid her only $30 a week board. Similarly, a parent is not dependent on their child merely as a result of that parent lending money to the child. You know, a relationship of creditor or debtor is not a relationship, of course, of dependency. Finally, that last point of if financial assistance has not been provided by the deceased, a legal right to such support from the deceased might be relied upon to show dependency. So, for instance, where there was an order made for child support that was never paid by the deceased, that might be sufficient to establish a right to claim. The one that probably sees the most controversy is this classification of in an interdependency relationship. The Act provides for the 4 criteria that must be established in order to fall within that category of claimant for superannuation. You must have a close personal relationship with the deceased, live together, provide one another with financial support, and one provides the other with domestic support and personal care. The nature of what is a close and personal relationship is not expressly defined in the Act. The explanatory memoranda to the amending Act described this classification as one involving a demonstrated and ongoing commitment to the emotional support and well-being of the 2 parties to the relationship. Under the regulations, there are requirements that must be taken into account in all of the circumstances in determining the existence of an interdependency relationship, similar to the classification of you know, a de facto relationship. It talks about duration of relationship, whether or not a sexual relationship existed, the care and support of children, the degree of emotional support. But this can sometimes allow, the definition is broad enough really to encompass, you know, brothers and sisters and these sorts of things as well. So that is one of, I described it as one that sees a lot more controversy because it is probably the broadest category in which you can try and establish an entitlement under. If you look at the requirements of an interdependency relationship, living together, on its face is uncontroversial. I raised the point there in the slide of the existence of an interdependency relationship can still be established if they were temporarily living apart, for instance, fly-in, workers or, whatever the case may be. It really turns on an analysis of the reason for any separation, if there was. Was there an intention to resume living together? These sorts of questions are relevant. But usually that is an uncontroversial thing and easily established. Whether or not there was financial support provided by one or the other, again, that's not financial dependency, that's financial support in order to establish that definition. Domestic support and personal care, importantly, it is excluded if it's provided under some sort of employment arrangement. That shouldn't be, of course, enough to satisfy that definition. It has often been described as a type and quality normally provided in a close personal relationship rather than by a mere friend or flatmate. Significant care provided to someone if they're unwell or if they're suffering emotionally may be sufficient for the purposes of satisfying that definition. This is an important inclusion in the way in which this section is interpreted, and that is the disability test. You can imagine a situation where somebody's circumstances are such that they may fall foul of the, for instance, living together requirement as a result of some sort of accident or illness or disability, meaning that one lives in a nursing home or whatever the case may be. This test has been inserted into the Act to ensure that those people, by virtue of an illness or disability, don't miss out on establishing a right to claim as a result of their disability. So they still, however, must show that they had a close personal relationship with the deceased. That's a non-negotiable. But the other requirements can effectively be overlooked if the reason for them not satisfying the requirement was because of their disability. The extent to which a person requires assistance with the activities of daily living is often an indication of the level of personal disability. Mere existence of a disability is not sufficient. So I broke my arm one day, won't do it. It needs to be a disability that means that as a result of it, the people do not meet the basic tests. And the example I used earlier is probably the best one. One of someone having to be admitted into a nursing home in order to get adequate care would satisfy this definition. So we've talked about the categories of people who can satisfy the definition, and it's not open to everybody. You can see from the way in which the legislation is drafted, there are discrete categories of person. But if you can be satisfied that that category, either being married or whatever the case may be, is satisfied, then the next question turns to, well, who gets it? What if there's multiple people who have an entitlement to claim by fitting into the category? What if there's children? What if there's minor children? What if there's adult children? These sorts of questions have to ultimately be determined. The general rule is that the trustee of the fund has a wide discretion under the trustee to determine how super benefits are paid. That's probably the first and general rule. Importantly, for the purposes of estate planning and also estate litigation, there are avenues by which the trustee's discretion can be removed if the deceased themselves prior to death put in place certain arrangements as to how their benefits are to be paid. And I've got the two most relevant ones there being making a binding death benefit nomination and also reversionary pension nominations. The terms of the trustee are really, really important. they determine how the trustee is to act on the death of a member. The next slide I've got extrapolated there, a cutout from a trust deed I saw recently that details how a deceased person's benefits are to be paid on death. It provided that without a request or direction, which you can take to mean that there was no binding death benefit nomination made, the trustee must pay the death benefit if the estate is solvent to the legal personal representative of the member. So under the trust deed, under this particular trust deed, if it can be shown that the estate is solvent, it will be, you note the use of the term must pay, it will be paid to the legal personal representative. So you might have a situation where a child is interested in making a claim on these benefits. Well, under the trust deed, as long as the estate is solvent, the legal personal representative is entitled to it under the trust deed terms. So I don't want to understate the importance of the terms of the trust deed. They are important generally, but they also can throw some curly, if you like, definitions about how it should be paid or how it should be treated. Superannuation trust deeds are allowed to be structured so that a nomination made by a member is binding on the trustee in relation to how death benefits are paid. They're not always able to be made for every retail and industry fund, although in my experience, most are moving, if not have moved, to a position where they allow some form of nomination and most are binding. There are some non-binding nominations, and I'll just discuss it very shortly, but it depends upon the terms of the trust deed for the fund. For most of the big players out there, there is an ability to make a binding death benefit nomination, which is a significant step that a now deceased person can take during their lifetime to ensure certainty about the payment of their death benefits. For instance, here in Queensland, Q Super for a long time allowed only non-binding nominations to be made. There wasn't an ability to make a binding nomination. So what that effectively meant is that the deceased person during their lifetime could give an indication as to how they wanted their death benefits to be paid without any obligation on the trustee to pay benefits in a particular way. Of course, if a nomination is non-binding, the trustee can take it into account and may take it into account and should, but it will not be bound by it. And effectively, it reserves its discretion to pay. But if we work on the basis that a binding nomination is allowed under the trust deed and importantly is valid, the effect of this is that the trustee has no discretion to determine the payment of the benefits and must pay them in accordance with that nomination. Now, valid binding death benefit nominations are largely unimpeachable. If it is valid, if it is allowed on the deed, there are very few avenues in which it can be attacked. I've listed there a couple of circumstances where it can be. The notional estate provisions in New South Wales that are specific to New South Wales grant the court a jurisdiction to consider the acts done by a deceased prior to death and the reasoning behind that in order to bring back assets into the estate that are now gone. So that's quite specific. And also family law, superannuation splitting and flagging orders. But for the purposes of our discussion today, if you have a valid binding death benefit nomination made under the term and is allowed to be made under the terms of the trust deed, it is very, very difficult to have that challenged on any circumstances. I mentioned there reversionary pension nominations because I indicated earlier that was another way. When people reach a certain age where instead of accumulating their super, they're now accessing their super, it's often paid by way of a pension to that person. And so under most of the trust deeds for some of these funds, it allows the person who moves to that pension phase to nominate what's called a reversionary beneficiary of that pension, of that income stream. Again, this is a way in which the trustee's discretion can be removed and you have certainty about where the benefits are going. That's usually put in place upon the initiation of the pension payment. So, you know, the client is usually provided with a form and said, do you want to make a reversionary beneficiary nomination and who do you wish to make it to? Again, certain classes of people can receive it. But if we focus on binding death benefit nominations, which are the most common, there's two basic requirements. Firstly, the trustee must allow the nomination, and the nomination can again only favour those who receive or who can receive it under the Act, being dependents and legal personal representatives. The additional requirements are requirements of form. It must be in writing, signed and dated by the member, in the presence of two witnesses over the age of 18 who are not mentioned in the nomination, with the proportion payable certain and readily ascertainable, and importantly, it ceases to have effect 3 years after it is signed. Now you might think, well, you know, what a ridiculous provision. Why would they have that? The reason why is because life changes, things change. And people often forget what they've done last week, let alone 3 years ago. And so it provides a mechanism by which these nominations can be reviewed. And really it's an acknowledgement of the seriousness of the act of making a binding death benefit nomination. What that means though, on a practical level, is you better make sure your details are up to date with your fund. Otherwise, when it comes close to that period of time or on an annual basis, we have the trustee acts, they'll be giving notice and telling you that things are about to expire. If you don't have relevant contact details in place, it might just go by the wayside and your nomination lapses. It's important to bear in mind that it is a bit unique, binding death benefit nominations. In terms of wills, there is a broad discretion conferred on the courts in most states and territories for the court to dispense with the formal requirements of wills and declare things wills which fail for form. There's not a similar power to overlook, if you like, deficiencies in form with non-binding nominations. If there is doubt, there's an ability of the trustee to apply to the court for advice, but not to fix. There was a recent decision which involved a member fully completing a nomination form in front of two witnesses and then mistakenly writing their birth date beneath the signature instead of the date on which the nomination was made. Now, in that instance, a tribunal declared that it was a fair and reasonable decision by the trustee of the fund to treat an invalid nomination as non-binding on the trustee. And so there's not an ability to really fix it. So it's quite an important thing to be aware of in terms of what is required in order to make a valid binding nomination, because there are very few grounds for review. Well, after everything that I've already said, it might be very, very clear why there would be benefits in making a binding death benefit nomination. The first point I say there is certainty. You know, we make wills for the reason that we want to provide some certainty about where our assets are going. It is an extension of that. If a binding death benefit nomination process is allowed and validly made, it will provide certainty as to where those benefits are going. The risk of litigation, and this is from an estate administration point of view, is very relevant to why it might be worthwhile making a binding death benefit nomination. You will remember from the class of people that can receive a superannuation death benefit of a deceased person is very wide and broad. Therefore, if the trustee discretion is being enlivened and the trustee, as it often does, calls for information from anybody who might want to claim on those benefits, you can imagine that it can sometimes give rise to a dispute, firstly, in respect of the superannuation benefits. But if the estate, or if the estate is enriched by those superannuation benefits, then it will bring those assets into the pool of assets which could be attacked by way of a family provision claim. So it is a very important issue in any estate plan that the risk of litigation is assessed, because you can make a binding nomination in favour of your estate, but if by doing so you're all but assuring someone's going to bring a family provision claim, well, there might be some value in directing that it be paid outside of the estate directly from the super fund to a particular individual. And finally, the last point there of insolvent estates. You know, who wants money that could otherwise be paid and benefited on our families to simply be used to satisfy debts and creditors who are sitting waiting for money to come into the estate? By having a binding nomination paid outside of the estate, it allows an avenue by which the creditors will not be able to get their hands on it, because it won't form part of the estate benefits directly. There are some reasons why you wouldn't. You know, you might hear me thinking, well, why would you just leave it? Why wouldn't you always make a binding death benefit nomination? The first and most important one is flexibility. You know, we as lawyers are trained to, you know, look for the risk and to look for the person in the woods who might make a claim, but there are many, many stable family demographics out there where allowing for flexibility to be retained is a more important and more value-laden decision than tying it up with a payment that is unable to be changed. For instance, if you leave it as a non-binding nomination, or if you don't make a nomination at all with a stable family demographic, it could allow, you know, taxation and financial advice to be obtained. And then as a family unit, you can make submissions to the trustees as to about how it can be paid. Now, it can be paid in proportions, it can be paid in pensions. So you could have some money going this way, some money going in another way. So it provides flexibility. And so it is not a default recommendation in an estate planning context that you must always make a binding death benefit nomination. And in fact, there are some very cogent reasons why you shouldn't or might not in a particular set of circumstances. Specific estate plans might otherwise be frustrated. By having a superannuation benefit paid directly to an individual, you lose the advantage which can sometimes be obtained by testamentary discretionary trusts in wills, or if you had someone, one of your beneficiaries was in an at-risk profession and you didn't want it to be paid to them personally, because then if they were sued in their line of work, the trustee in bankruptcy could get into their shoes and distribute their entitlement to them. So there might be some very clear and specific estate planning tools that you might want to achieve, such that it is best not to make a binding nomination, or potentially make a binding nomination in terms of the estate. And finally, that last one, there's a broad inability amongst the industry super funds and the retail funds in making cascading nominations. You know, in your will, it is not unusual at all, and in fact quite normal, for you to provide for your estate to go in a certain way to somebody, but failing that, if they predecease you, this is how you want it to go. Most of the funds that we deal with don't have an ability for you to make cascading nominations. And so as a result of that, sometimes the attraction of making those nominations is reduced. So we talk about the next stage. You know, if someone's died, they haven't made a nomination, so it is the trustee's discretion that's going to be applied. Now, once again, this is working on the basis that there's going to be a dispute, or at least multiple people claiming an entitlement to these benefits. What happens is the trustee of the fund sends them all paperwork. It asks for information from them. It asks about the nature and the degree of financial dependency they had, the quality of their relationship, the current and likely future needs. You know, all these sorts of questions are usually contained in their form so that they have an idea about, well, who has the strongest claim on these benefits? And it informs them so that they can make a decision about how they're going to pay it. Again, those the criteria there, which I've got down there, are not enshrined in legislation, but have been obtained from some of the factors that the tribunal that ultimately determines these things sometimes considers when determining these sorts of disputes. Importantly and generally, spouses at the date of death are generally preferred to adult children. Now, depending upon who you're advising, you know, that might come as a shock or a comfort, but that's a very general proposition that can sometimes be addressed. You've got a decision. Everyone's got in their paperwork. They've made a decision. They've made a decision to pay it a particular way, and your client doesn't like it, or your client loves it. There's still an ability for a trustee's decision to be challenged, and first point of call is an internal process where you object to the decision within the actual superannuation process. They then ask why you're objecting. You give decisions, you give reasons rather than submissions, and then they remake the decision or they affirm their previous decision. What they then do is send a letter out giving written notice, right, this is our final decision, and everyone's got 28 days. If we don't receive any objection, we're going to proceed. But if you do wish to object, your next port of call is the Superannuation Complaints Tribunal. Now, only a person with an interest in a death benefit can make a complaint to the SCT, but usually if they've been allowed to make submissions or they have an entitlement to claim, that's sufficient. But what happens then is the obligation on the person seeking to agitate this to then lodge their objection and their application with the tribunal. I should say that there are the usual common law principles of reviewing a trustee's discretion. They remain and are available through the relevant state or territory courts, although they are rarely used, and for the reason which I'll come to in a moment. Of course, if a complaint is not raised, the superannuation trustee proceeds with its decision. Now, the tribunal is an independent statutory tribunal that provides consumers with a free service for resolving complaints relating to superannuation funds. Now, it is free to access. That is a great benefit, but it's also a great curse, because it sometimes provides an ability for someone who might not have merits in their objection to pursue an objection to the absolute death, and by doing so, delay the release of those benefits by the superannuation trustee. You can see there that the funds, the trustees of each of these funds agree to abide by any determinations by the tribunal as a condition of their superannuation entity licence. So if you're wondering then, you know, why does the tribunal have a jurisdiction to tell these trustees what to do? That's the reason why. They agree to be bound by it under the terms of their licence. Generally speaking, as I've got there, the complaints are lodged by the individual making the complaint. Importantly, there's a presumption against representation. You know, they're trying to keep the lawyers out. Sometimes that's a good thing, sometimes it's a bad thing. Usually, they will allow someone to be represented where they have a disability or they consider there is a need in all of the circumstances, but they must allow the representation. It is not as of right. As I mentioned before, they can only accept disputes where the individual has already been through the internal dispute resolution process of the superannuation fund. So sometimes someone gets a decision of a trustee, not the final one, this is just the indication of what they're going to do, and then they rush off and complain to the SCT. And the SCT turns around and says, well, I'm sorry, you haven't gone through the internal complaint process with the super fund, so they're not going to accept the complaint. I've got there, this is from the super fund's own website. It just, not super fund, rather the SCT's own website. It just gives a helpful visual diagram, if you like, about the way these complaints proceed through the system. The inquiry is exactly what it is, people looking for information. The complaint is made, The SCT then makes a decision about whether or not it's something that they can deal with. They then gather information, ask for information from the parties, and then the first point at which the parties can at least attempt to try and resolve it is at a conciliation conference. Now, my experience has been that it's completely dependent upon the personalities, both within the tribunal and also the parties that you actually have at the conference. You know, if someone doesn't want to be pushed around by the conciliator, they're not going to do it. And my experience has found that sometimes that's just how it ends. Sometimes there is a very good result, and the first ability of the parties to actually sit down and have a discussion can sometimes find a way through. If, however, the conciliation does not resolve it, then it moves to the next stage, which is review. Now, these reviews are conducted on the papers. The chairperson constitutes the tribunal by selecting 1 to 3 tribunal members for the purpose of dealing with the complaint. The complaint is scheduled for review, document exchange occurs between each of the parties, and they're provided with the opportunity to make written submissions. Then in exchange, obviously procedural fairness is a common theme in these processes. The SCT then stands in the shoes of the trustee and must consider whether the decision of the trustee was fair and reasonable in the circumstances. If it decides that it was, it affirms it. If it decides that it was not, it must put the complainant back in the position that they would have been before the decision was taken. So it precludes any actions for damages or anything like that. It can consider it on its merits. It can make its own findings of fact. And as we discussed before, any decision of the tribunal is binding and must be proceeded with by the trustee. Otherwise, it can itself find itself in a bit of trouble. That last point is probably the most significant in this whole process, and that's there aren't any costs awarded against or for any parties that go through this process. Again, that is a benefit, but it's also a curse. It means that there's no risk, there's no deterrent. You know, why would somebody not make a complaint if it can somehow give them some leverage in any negotiation? But that's the structure and the scheme in which we've got for the moment. But it's important to realise there is an appeal process, and this is where the cost can come into it. When you appeal to the federal court, but only on questions of law, you can't appeal it because you say that they came to the wrong conclusion on the facts. The federal court, importantly, can't make adverse cost orders against an individual that does not defend an appeal. You know, so if it's in your favour, it's been in your favour since the start. The review process finds it's in your client's favour. You can't be penalised for not then going into the federal court realm and finding yourself faced with some sort of cost order. These are quite stark. I was myself, when I was preparing for this presentation, surprised at some of these statistics. The SCT load has, from 2004-2005, has increased from about 1,900 disputes to 2,700 disputes in 14-15. You know, that's a 40% increase, effectively. You know, that's huge, really, from a government body. But what it shows, I think, is the way demographic pressures are changing. There's an increased financial literacy that Australians now have, and there's a growing engagement and understanding the superannuation. And what this means is that people are now aware of their rights, which is not a bad thing, but it means now that these systems have been accessed when people feel that their rights have been infringed. What this has resulted, though, in is the experience of significant delay sometimes within these processes. You can see there that that's a quite extraordinary figure. In 2015-16, the average time in days to resolve a dispute from lodgement to determination was almost 800 days. You know, that's an extraordinary period of time for someone to be involved in a process that might have been in their favour since the start. And of course, this doesn't count the process from when they initially applied for the superannuation with the trustee, And so what you're looking at is an extraordinary length of time, which can have a significant effect on clients and also their families. That's again a visual aid to show the way in which these complaints have increased over the years. There's a recent review that has been handed down in April by the federal government into the Superannuation Complaints Review, but also a number of financial ombudsman services. And a number of recommendations came out of that process, but most importantly was the establishment in the middle of next year of the Australian Financial Complaints Authority. Now, this authority will replace the Superannuation Complaints Tribunal and amongst other ombudsman and financial services as well. Finally, in terms of future directions and trends, there is, in my view, going to continue to be an increase in litigation in respect of superannuation benefits. I'm seeing it almost on a daily basis, where estates, people have passed away with not a brass razoo except for $100 in their superannuation worth of accumulated benefits, and then $200,000 worth of life insurance benefits. And then it's on for young and old. And so I'm seeing that in my practice, and I think that will continue to increase the way in which the system is currently designed, but as a result of the nature of assets that people now hold. You know, the ageing population, the increases in personal wealth, it's all going to add to that prospect of increased litigation. I think there remains and will always be an importance for clients of engaging competent legal and financial advice in the preparation of their estate plans. You know, there remains this idea out there that it is simple, anyone can do it, and you just got to fill out the post office will, but often all people are doing is shifting the cost. They're shifting the initial cost of preparing an estate plan to the family once litigation kicks off in respect of the way in which that process was undertaken. Look, thank you very much for that today, James. I hope that's given some people a bit of more of an insight and understanding of the way the superannuation works upon death. And thanks so much for joining me.
Terrific, thanks, Tim. Probably a few minutes to ask questions, folks. A reminder that you can ask questions by typing something into the questions box or by pressing that button that looks like a hand on your webinar control panel. Tim, you're sitting at a community legal centre's evening drop-in advice centre. I come in and I say, my father's recently passed away. He remarried. I don't get on particularly well with his new wife.
Yep.
I think he had some money in super with Australian super. From your perspective as the CLC lawyer providing the advice, what are the key next 2 or 3 questions or 2 or 3 sources of information that you're going to go to put yourself in a position to provide me with information about any entitlement that I may have to my deceased father's superannuation fund?
It's a good question because of the relevance of it from a CLC point of view. The first question I would ask was, did your father have a will?
Let's assume that he did.
Okay. First thing, from my approach to that question, unless the person is aware of who the super fund is, and they can direct their inquiry to there directly, often people don't know. Sometimes the employer that they had at the time will know, and sometimes a discreet request of that entity can be quite a fruitful one. But the first and foremost point is, do they have a will? Particularly from a Queensland perspective, there's an obligation on an executive to provide a copy of the will to a child, a certain category of people. So I would ask for a copy of the will, and I would ask for details of the assets and liabilities of the estate. That's my first point of call. That should disclose the existence of an account with a superannuation fund, which then you can direct your inquiry to. As I am interested in claiming these benefits, I'd like to do so. How do I do it? And they will often, and as a result of the claim staking process, they must send you out material, provide you with documents to fill out that you can start that process yourself.
How does that explain with their confidentiality obligations? How do they know when I pick up the phone to them that I have an entitlement to see those documents? What's the decision-making process there?
In terms of the superannuation funds, they will likely give you very little information over the phone. I agree with you, but as part of their process, they must identify all who have an interest. And so I would expect they would take note of what you're saying, find out if there is a member that they have, and then probably say to you, well, could you get the executor of the estate, or, you know, someone to get in contact with us. If that is the case, do you have a copy of the death certificate? You know, these sorts of things to try and feel out the relevance of this. You know, because it's not uncommon for people, as we've talked about before, to make an inquiry before mum's died or dad's died. That's quite usual. I think I might have mentioned this the other day. I had someone call me the other day and said, look, I want to know how do I know if my mum's died? And I said, well, you've probably betrayed the nature of your relationship with your mum, but, you know, no, they won't talk to me, family won't talk to me, right? I'm checking the paper every day, she said, right, okay. So everyone has different ideas about finding out, you know, information, but from the point of view of this, a methodical way, but take comfort in the fact that these trustees must find out who has an interest.
Thank you to those that are saying to send through some questions, and I hope I don't butcher them up in the interpretation here. Is it the case that if a beneficiary advises the relevant fund that they do not wish to be considered in a determination of death benefit, will this be considered by the trustee in their decision? Yes.
I guess it depends upon how they've advised them. Usually the process is that they will provide all the relevant material to people with an interest, and there is in fact a form in there that says, I do not wish to be considered. And so if the beneficiary has signed and returned that, yes, it would be considered, and I would be extraordinarily surprised if they were considered for the benefit against that notification.
Another question that's come through, many people don't even know what their own super funds are.
Yep.
Often we're directing them to the ATO who can kind of capture that information for us.
Yeah.
Can their children contact the ATO or the executor of the estate, the personal representative? Can they contact the ATO to get that kind of information out of the ATO about the existence of multiple superannuation funds?
I'm assuming the person in question has died and these inquiries are being made. Yeah. Well, the first thing that would need to be established, particularly from something like a body like the ATO, is they're particularly vigilant in who they're giving information to, given the nature of tax and financial information. So they would want to be satisfied that the person who's asking the questions has an entitlement to do so. So if you had a will, or if you had a grant of probate, or if there is no will, you would need a grant of letters of administration, presumably. You know, you would have to establish your entitlement if your parent or the person who you're seeking to make inquiries of, an entitlement to ask information on their behalf or their estate's behalf.
Thank you. Can I come back to a point that you kind of raised before? A lot of the work, increasingly, the work that community legal centres are doing is with older people who are at risk of financial abuse.
Yep.
And so I have a question about the form of the nomination where the signature, so an older person has kind of out of the blue signed a nomination and the witnesses are two of their adult children.
Yeah.
And given that adult children are so often the perpetrators of financial abuse against older people, what extra protections are embedded in this system to protect older people in particular, but, you know, superannuants generally, I guess, around that nomination process and making sure that they're not coerced or otherwise pressured into making a nomination.
The first point is, I think, is that the usual issues in respect of testamentary documents probably applies, and contracts generally, really. That if it was the case that you had an elderly client who attended upon you with a nomination that had already been signed, well, the first point is that if it had been signed by the children, then under the Act, they can't benefit. So if they were trying to financially abuse mum or dad, they should be clever enough to make sure they're not going to be the witness. But if there were some concerns about it, one of the real downsides to this process that I've found is that the superannuation fund does not make an assessment at the time of receiving a nomination about the nature of this nomination. Now, if there's a glaring issue, you would hope that they pick it up. But I've had some situations where someone has nominated their brother 100% and sent it in. Super funds turn around and said, yeah, thanks for that, mate. Thank you very much. That person's then died. They then pull out the nomination after receiving notification of death, look at it and go, oh, well, you can't nominate your brother. He's not a dependent. And so then the trustee's discretion is enlivened. And so, unfortunately, the process isn't, and particularly my experience has been the trustee's ability to pick that sort of stuff up at the time of lodging the nomination is not clear, but usually at the time of death, those sorts of things are made, and by that time it's too late.
And so I guess the question that follows on from me then is, to what extent can a nomination be challenged on the basis of the capacity of the person making the nomination at the time they make the
Sure, it absolutely can. And the courts retain an inherent jurisdiction to do so. And so it would be like, similar to, someone signing a will who didn't have capacity. It would go through the process in terms of the trustee. So the trust might themselves seek advice. The trustees of the fund might themselves seek advice, or there would in fact be a challenge or a declaration made by the Supreme Court as to the validity of that document.
Another question has come through, Tim, and we might make this the final one. So the ATO, coming back to the example that came through in the question before, if the ATO doesn't release the information because you haven't obtained a grant of probate or letters of administration, how else do you find the superannuation funds of the deceased, particularly these days when most statements aren't being sent electronically, not like the old days when you used to just go to, grandma's shoebox full of official documents. How do you find people's superannuation?
Well, over and above that, it's really difficult. It's like trying to find someone's will if you don't know who their lawyer is. That's when advertising and things like that. Not that you would advertise to see who has a superannuation fund, but you've just got to do your best with what you've got. And if it is the case that the ATO is not proving fruitful, you've just got to do your best. You've got to try and find a way, whether you contact the employer, find out who they were contributing into. They should most of them will tell you this information. The bigger the organisation, the more privacy they have. But if it's a one-man band who employed him as a plumber down the road, I'll just get that out of the filing cabinet. I'll tell you who it is. That's how the practical reality of the situation is. But again, it's about trying to find a way to identify it as best you can.
We've got some other suggestions or questions about how people might convince the ATO that they should share that information, including death certificates and the post office will, in inverted commas, and own ID and those kind of things that they've used. But I think that's a question that would be particular to its circumstances. Tim, can I thank you again for yet another engaging and practical and kind of in areas of law that some of us in CLCs don't always think of as part of our core business, but walk through the door surprisingly often. So thanks to Tim. Thanks to everyone who contributed today. I'm sorry, I think there were some technical issues when we got started. So hopefully those that joined followed everything, and we hope a recording will be made available in the next day or two. Thanks very much, everybody. We look forward to speaking to you soon. Bye.